Hi, my name is Alauzen. I'm a sociologist, and with Denis Merigoux, a computer scientist, we will present you the paper we draft with Lyria Bennett, a lawyer. So, our interdisciplinary research is about rules, computation, and politics, in the case of unnoticed programming choices. Let's start with our case, the French housing benefits. The housing benefits were created in 1945 after the World War and have undergone multiple reforms since then. So you just have to remember that since the 90s, there's been an increase in the number of beneficiaries, and also that's one of the first measures that President Macron has introduced at the beginning of his first mandate, was to reduce the number and the amount of the subsidy, which is considered to be both costly and inefficient. It still concerns, it still concerns 5.5 million beneficiaries and costs 80 billion each year. So because of the historical sedimentation of rules, the calculation of housing benefit is very, very, very tricky. The official 80 pages document that details the calculation indicates 6 modes of calculation, of computation, and 4 formulae. Moreover, there are tons of exceptional cases. And since the end of the 90s, within the French administration, what we call the CNAF, an information system named Crystal computes social benefit for housing subsidies. But in recent years, there have been many public controversies about calculation and access to social rights. Consequently, we decided to investigate the source code of Crystal in order to contribute to the public understanding of the issue. So our objective was twofold, both to understand how housing subsidies are calculated by the Crystal software, and also to grasp how the text framing the calculation are written by ministries and by the legislator. So the CNAF uses Crystal since the late 90s. The source code has been written in the old programming languages COBOL and has recently been published. So more precisely, the CNAF sent Denis a CD-ROM, but it is unreadable and useless for in-depth investigation and testing. That is to say that Crystal is not crystal clear. Consequently, we decided to simulate the production of the source code by ourselves. What does simulate the source code mean? It is not a question of replicating the condition of production of information system like we do in the 90s. It implies, first of all, to gather in a same document all the texts that frame the calculation of the housing benefits. It's over than 100 pages. Then to translate every article in computer code. The 100 pages document has resulted in 7,000 lines of code. How? Thanks to an hour of pair programming between the lawyer, Lyria Bennett, and the computer scientist, Denis. Pair programming is the very moment where they both interpret the rule of law and stabilize its computer writing. They therefore make programming choices. The simulation of the CNAF source code draws on the Catala methodology developed by Denis Merigoux a few years ago. It is a literate programming methodology that supposes that both code and law are isomorphic. It implies intense discussion between the lawyer and the programmer. And the code produced is opened in GitHub. Here is a link for public access. So then, to verify that the programming choices represent a valid simulation of the calculation of housing benefits in France, we attempted to meet with the CNAF in vain, and then with the ministry that regulates housing law. We asked them very specific questions about the interpretation of the law. In short, we conduct interviews and we exchange many emails. More precisely, we asked them about how they work on housing law and how the computation rules were written. The documents exchanged with the Ministry of Housing were structured by first the article to formalize, second, our interpretation question triggered by pair programming session, and third, the answers the drafter of the law, of the article of the law sent us.
Thank you, Mary, for the introduction. And so with that methodology and investigations, we have several results we want to present to you today, and they can be found in the paper for more lengthy discussions. The first result is that our simulation uncovered a series of micro-choices and divergences that programmers have to make when they translate the text of the law into computer code. And this is a formalization process that has been mentioned earlier in the discussion today. I'm going to focus on a specific micro-choice that we uncovered because it's the most maybe interesting. There are two kinds of housing benefits. There's an old one and a new one. And there's an article that says that if you can't have both at the same time, you have to choose between the old one and the new one. But the phrasing of this article may imply that actually, if you're eligible to both the old and new benefits, you're forced to take the new. And actually, there's an interpretation dispute because we asked the housing ministry and they said, oh yeah, in that case, when you're eligible for the two, you always take the new one. But actually, it's not exactly what the text of the regulation says. And we say that, oh, actually, you can also take the old one. And the decision between if you take the old one and the new one has to be with regards to the financial interest of the applicant. And however, the general understanding was that the new housing benefits is always better than the old one. But actually, since those are two complex programs of calculations, we found a corner case where the old one had a better financial interest than the new one. This is actually a corner case, and it highlights that even though drafters are interpreting the law that they write with a specific policy goal in mind, that policy goal may be defeated by the actual precise computation that they write towards implementing that policy goal. So to give you a taste of what these corner cases look like, this is the computation. So you can see that the kind of flows that we're dealing with are really not the kind of like high-level law on human rights and stuff. It's the text of the regulation actually has mathematical formulas, and to apply it, you have to make a series of computations that are actually quite complicated to do even by hand. It takes approximately 1 hour and a half to complete those calculations. And then you have to have 2 or 3 people that cross-check each other because each step can be prone to error. Which is why it's very important to have that done by a computer machine, because it's actually better if the code is debugged, of course. The second result of the study is to bring a more sociological perspective on regulation making, especially with this type of program that is finally destined to be programmed. The regulation is here to state that you have a form that you fill to apply for the regulation, and then the state computes how much benefits you're entitled to. And then the regulation makers, they know that the form exists, they know that the CNAF is going to compute the amount, so the regulation is destined to be transformed into a computer program. It's its primary destination. And that contrasts with other types of law. That may be a useful addition to a nuance to the categories presented by Mireille and Giovanni earlier in the day. Moreover, these regulations, they're not written by lawyers because they have this specific status. They're written by civil engineers, the ones that build buildings, because we're in the Ministry of Housing, so the Ministry of Housing is populated by civil engineers, and when there are laws to be written about buildings and housing benefits is part of the law about buildings, then civil engineers write it. These regulations are constantly rewritten. For instance, we told the Minister of Housing that some regulations were poorly drafted and there was an ambiguity, and they told, oh yes, what about this formulation? Would it be better to understand? And so this was a month ago, and they haven't published the new form of regulation, but it's a constant process of improving the text. And this doesn't go for Parliament. This is all done within the ministry because it's all executive orders. And moreover, the last point is that those regulations, they're constrained by technical limitations. For instance, the minister says, oh, we want to change that. And then the Ministry of Housing say, okay, we're going to fix that text. Then they communicate the text to the CNAF. And the CNAF says, well, actually, we can't do that. And then the Ministry of Housing say, okay, then we'll rewrite the law. And this is how it works in practice. And I want to stress that out. And this is the primary constraints that Giovanni was talking about. They're not hardware, they're software. The CNAF has technical debt. They can't change the behavior of the software because of the technical debt. And that is a limitation to the power of regulation from the Ministry of Housing. And it's actually a regulation quagmire. There has been a lot of debates and controversies over that in France. So overall, the key takeaways of this paper, which I encourage you to read, we can have a takeaway for legal informatics. Because the process of simulating the production of the source code from an actual piece of real-world legislation used to somewhat impactful level shows that, yes, the model created by the regulation matters, even if it's poorly structured. It's the model that effectively determines the right of people, so we have to take it into account. We weren't trying to simplify the computation of housing benefits according to a more elegant model of computation. We had to stick with what was in the law, in the regulation. For the philosophy of law, the takeaway, a bit controversial, would be to foster lawyers to interest themselves of the problems at the bottom of the hierarchy of norms rather than at the top, because the problems at the bottom effectively determine what people get effectively. Even more so at the programming level. And about sociology of law, and this is for a key takeaway from my colleague, is that studies about sociology of law must diversify for the investigation of the mundane legal technology and not only the noble activities of legislative drafting and the high courts of cassation and the high courts. No, you have to also go at the mundane level of the, so there was this expression, the street level bureaucrats. So they're not street level bureaucrats, they're system level bureaucrats, but they're not high level system bureaucrats, they're low level systems bureaucrats. And the work they do is also interesting and worthy of public attention since it determines a lot of the enforcement of the law. Thank you very much for your attention, and we can move to the replies.
You still have 2 minutes? Do I understand you're still going to speak?
No,
No,
it's
Oh,
okay.
okay, sorry, then you're...
It's just,
You said max 15 minutes, and
Yeah.
I tried to keep it short.
This is all about the rules, right? Lyria, are you with us?
Yes, can you hear me?
Yes, perfect.
The only problem is I can also hear myself. Let me see if I can stop that happening. Oh, I think they might have stopped it for me. We're good. Otherwise, I had an echo. Thank you so much, first of all, for letting me dial in from Australia. I've loved listening so far. My son finished school with his last exam today, so it was a privilege to be able to be here at home in Sydney on Gadigal land. So looking at this paper, I really enjoyed it. I've already said this to Denis earlier, but it's a really great paper. And as he said, I really strongly recommend everyone read it. The point I want to focus on is, where to from here, right? What are the implications of this? And I was thinking largely around the implications for the rules as code movement. So what's the end game? Now, rules of code is a sort of interesting view on the world because it doesn't start with the first question that Merigoux took us to of like, should we do any of this? What is computational law? Is it a good idea? But it sort of starts from the premise of, okay, we're already putting things in computer systems. How do we do it better? Now, if we're looking at the example in the paper from France, in fact, it's a classic use case for computational law. So, sometimes rules as code people will disclaim the ability to use these techniques for certain kind of hard situations. But the example in the paper is exactly the use case. It's exactly the task that rules as law claims to be able to help with, and computational law indeed claims to be able to help with. So we've got an ideal use case. So the paper goes through various kinds of problems. There's some sort of beginning problems that were just discussed about, how do you even get your hands on the code for this? But when they were creating it in Catala, the issues were the micro choices, so imprecision, simplification, and invisibilization. And indeed, not only was these issues interesting, but the absence of the original source code base was also interesting, and means that I was really struggling. So the combination of all those things is when I went back to my question of what does this mean for the rule of law, I struggled. Because on the one hand, I felt that the paper really demonstrated the importance of the rules as code ideas. But on the other, it suggests that it's really hard and maybe even impossible. So let me break that down. And I'm going to break it down by some of the ideas that come out of rules as code. So one is transparency, the fact that the code should be rendered transparent. And this was really the first part of the paper, right? That they couldn't access the source code. And the importance of transparency for being able to critique the way these kinds of laws are implemented came across as paramount. So on the one hand, super important. But on the other hand, as the paper explains, also really hard. Is the coding language used ones that modern experts are used to interpreting? Is it stored in a medium that remains accessible so that the code can be extracted or run? So again, coming back to rules as code and transparency, what might be required more than using that word? So if we want to make accessibility real, we can't just say, have it available. We have to have it available in a certain sense so that it is actually usable. So the next thing rules as code talks about is code drafting. So the idea here is an interdisciplinary team, all of whom are part of the project, ideally working at the same time. The laws are being drafted in the natural language, and the code is being drafted at the same time. And again, the paper really highlights the importance of that kind of multiple people approach, largely because of the number of errors that were in the laws. And maybe this idea of multiple people at the same time, someone's trying to code it, someone's writing it in natural language, would pick up some of those errors. And possibly even in an ideal world, this could solve some of the sort of micro choice questions, at the moment of drafting that came up in the paper. So one of the questions was, one of the issues was that you had to know the date when the 3rd month of pregnancy began for an individual to be able to work out their eligibility for a particular benefit. And the point the paper makes is that even asking that question conflicts with privacy rules, right? Because, do you really want to say what was the day the child was conceived to be able to work out the relevant month of pregnancy? It's best dealt with not by the coders, it's best dealt with by changing the original law so that you don't actually collect that information in the first place, but pick some other test that will get you to the right people who deserve the benefit without asking so personal a question. But that makes also several assumptions. It assumes that the code drafters, the legal and policy experts are aware of the corpus of law as a whole, right? So they would spot the inconsistency with privacy and data protection requirements in this particular case, or wherever the other requirements are coming from. But the evidence, from the paper itself suggests that actually that might be incredibly optimistic. Your code drafting team might not be lawyers because the policy people who drafted the law in the sort of classic framing might be engineers or something else, right? So So the assumption that code drafting is interdisciplinary in a particular way, in the similar sort of way to the event today, might be a false one. And similarly, you know, another example that's given in the paper, the sort of corner case, the one where, you know, it was assumed the new system would always be better, but in fact it isn't. It's just a false assumption. But the false assumption was from the people who are actually responsible for the law, not necessarily. So who is the person picking up the problems? Do we have the right people in the room? Would we ever, in a real world scenario, have the right people in the room? Another challenge for code drafting is it kind of assumes you do it at one point, right? You start the drafting process, you get the coders in the room at that time and everyone's working together. But of course, the big challenge the paper raised is that it's constantly changing. So do you need to always have a multidisciplinary team every time you make some change on page 130 of a code book? So again, challenges. Isomorphism, again, important, right? The idea that the code and the law align, but really hard in practice. And the whole idea of micro choices really demonstrated that. So we think about, you know, rules as code already talks about the problem of, you know, rules like good faith and the fact that, you know, how do you make that isomorphic? But I think going back to that point about this being a kind of ideal case study, it's micro choices everywhere that you look. So, you know, where do you go and how do you actually achieve isomorphism if you're always having to make choices, where even the order in which you fill out forms might affect an outcome? So my big questions to wrap up. What does the paper mean for rules as code as a movement, both within the public service and also within particular communities of lawyers, legal scholars, computer scientists, and so forth? Is the rules as code mantra help? So the idea that they're going to do it anyway, we'll just help them do it better. So is it still worth pursuing rules as code ideals because it's better than the alternatives? As an aspiration, even if recognized as a practical impossibility. And if we are still going to try, how will rules as code engage with all the complexity of the real world identified in the paper? So Merigoux began earlier on talking about how the big questions often come down to empirical ones. How can all the good sounding things, transparency, code drafting, isomorphism, really happen given the challenges identified in the paper? So thank you to Denis and colleagues. It was a great paper. Yeah, it raised a lot of questions for me.
Thank you very much, Lyria, because it's 9:44 in the night from where you're speaking, right? So very much appreciate you joining us with such energy and great questions, which now are going to be resolved by Denis and...
Thank you very much, Lyria, for this wonderful reply. A brief point on accessibility of the code. I think, and it's been my public position that I repeat here, is that what we need is not transparency, it's reproducibility of the code. And this is a more general problem in science. For instance, you have this lack of reproducibilities of studies. And for that, in computer science conferences, we have this policy that code artifacts that support the claims made in a paper must be made available publicly. And there's an evaluation as the review process for the articles that goes for the artifacts. And there are several criteria that very practical criteria to make sure that the artifact is so inspectable, runnable, reproducible, and executable. And I think we can import those same kind of requirements and policies into the problem of transparency of the code for rules as code and public algorithms. For the more general question of whether the future of rules as code is good is going to be optimistic with all those challenges that we raise. Of course, the paper is written with a negative lens because we focused on the things that go wrong, and because we follow the principle laid out by Mireille. Of course, you have to look at the things when they go wrong. But overall, the result of this study is mostly positive because we're able to produce first software that computes the housing benefits, as the Crystal software is doing. So this was not a given at first when we started, but we actually managed to do it. Plus, we managed to do it better sometimes than what Crystal is trying to do, because we weren't burdened by technical debt. For instance, there's a big problem of splitting housing benefits in the case of split custody for parents. And there's a problem that the CNAF isn't able to do it because of technical debt in their IT systems, technical debt which we haven't, and we're able to produce that computation in our simulation. And I've written an administrative report about that, focused specifically on the implications of what I've found for the French authorities. And overall, I think that, yes, there are ideals of rules as code, and there should be ideals, but our approach is a very reformist and pragmatic approach, where we try to better things a little bit at the time. And we're aware that we can't reach the ideals, and even reaching the ideals is sometimes problematic, but we try to make our path by gradually improving and suggesting concrete improvements, and that's why I've made this Catala thing, which is a tool, I don't view it as an end in itself. It's more of a tool, concrete tool that you can use, but targeted on those ideal use cases of rules as code. I wanted to start with the fit tax and social benefits computation, because they've been objects of research for like a lot of decades, but situation on the ground is still far from ideal. So I think we still got to work on those simple use cases before we can move on the more complex ones.
Especially after seeing how not simple they are. Questions? Can you say your name? Robert Doesburg. More questions? Okay, Robert, please, you have the floor.
Yes. Thank you for your talk. I have a general question that's about all we have discussed until now. Well, usually we see law as a hard constraint. At least that's what I'm always told. And now I've heard several times that the law actually is a soft constraint. Can you elaborate on that? And maybe others as well.
I mean, I don't think it's a soft constraint, because the people that are receiving their benefits, they just fill the form and they got the number, and either they accept the number and and if they feel they've been wrong, they can enter this like lengthy appeal process, and then they receive letter that go, your appeal was denied. And then what can you do? Oh, you can go to administrative court.
I understand. In that sense, it's hard. But you also said, well, if we can compute it, we change it. Well, that seems to be rather soft to me.
It's soft in the sense that the changing mechanism for this kind of regulations doesn't go through Parliament. It's a unilateral decision by the ministry, and it can change whenever. So, indeed,
but
it's soft.
It is material law, isn't it?
Yes, it is. But all the changes that we've suggested and that they've enacted, they don't change the amounts that will be received by people. They just change the way, the rule expression, as Gianmarco was saying. They don't change the rule, they change the expression of the rule in order to make it more comprehensible and transparent, but they don't change. Of course, if we were to change the amount of benefits that people were receiving, this would require a much more higher level of approval than just the low-level bureaucrats at the Ministry of Housing.
You mentioned it yourself, that this seems to be some kind of a soft constraint, like what Giovanni Soleno was talking about before.
Yes.
That was what brought me to my question.
Okay, because of the technical debt thing?
I don't remember.
Okay.
So what you're basically picking up, and that's very interesting, is that within administrative law, if a government has certain legal powers to impose rules in the context of the law, you could say, then those powers could be termed as administrative. We term them in Dutch. I wouldn't actually know the English term, but actually I do. So in Dutch we say wetgevend en regelgevend. You understand Dutch. I think in English it would be legislative and regulative. And a piece of legislation is hard. The regulation is a policy interpretation. to make things workable, to operationalize, and there has to be a legal power attributed to the minister in this case to make that sort of policy rules or regulation in English. That is law, but it's under the rule of law. So the attribution to be allowed to change those rules is under the rule of law.
Yes.
And in that sense, I would say it's not, maybe the use of terms like hard and soft is extremely confusing because it means so many different things. It's like talking about text-driven or text-guided. A bit worried that with guided and soft, suddenly it becomes part of a sort of social science relativism. Well, you know, the law is whatever some folk decide who happen to be judges. But that's absolutely not how it works. There is a very specific hardness that if you know the case law and the details of the case law, you also understand that that hardness is not a naive hardness. It's not like, oh, there is some sort of rule that's always going to be applied in the same way, because rules cannot interpret themselves. And I think particularly these issues that I think are intuitive to lawyers, but as soon as you come out from the outside, like a sociologist or computer scientist, then the terminology begins shifting. And that's what we have this conference for, to elucidate what is the difference between legislation and regulation, how the regulation is under the powers that we attributed, what that means, and how that relates to the difference between writing legislation as code and actually sitting down in a ministry, making decisions, building a policy so that people sort of can anticipate how this law is going to be applied in a concrete case. And what happens at the legislative level, what happens at the regulatory level, and then the question of soft and hard is maybe dangerous terminology. That's what I'm trying to say.
So really to bounce on that, you have these legal constraints, but then you have the political and budgetary constraint, because every change in the housing benefits legislation has to be approved by the Ministry of Budget. And we discussed with them, and they really scrutinize every change that goes into those housing benefits, because they know it's 18 billion euros, and 80 billion euros is a lot. So there is not only legal constraints here. It's part of like the bigger administrative body of constraints.
Thank you.
Hi, Jet Singh from Cambridge. Yeah, thanks for the talk. Really interesting. Yeah, it was interesting as well hearing about, kind of policymakers of the ministry, and then you have like the technical people programming things as well. In a previous life, before academia, I was working in developing public sector systems, and there was the all-important business analyst, which would kind of be the go-between between the two parties, right? So their whole job was to actually really engage all the different groups involved, and often would have representatives from each side working to try and build things forward. So I was just kind of curious if you think, well, who could be involved in trying to deal with these sorts of problems? Because you could imagine lots of the kind of micro choices you had to make could actually be ironed out quite smoothly as part of a software engineering process that involved better engagement with the BA team or whoever it is. So I was just curious if engaging more actors or having some other software engineering processes embedded as part of that might help some of these uncertainties go away.
Definitely, but what we found in the field is that there is no such software engineering process. There are no processes, basically. This activity of transforming the law into code is really made by like there is in all the ministries an office that does that, because you have to do that, but it's not part of thought of process. They just happen to be there and they do their work, and like they phone the business analyst people. There are business analyst people also in another office, but they don't think of themselves as being business analysts or coder. They're just like, they're civil servants. Their background is random. Just happen to be in the office at the right time, and they just learn the work. And there is no like organized reflexive process of organizing that process. And I think with respect to the rules as code challenge, I mean, all the rules as code people are really trying to build those processes, but at least in France, they're not here. And
not all systems are built like that.
yeah, I mean, not all systems, but so I'm part of the formal methods community, which is a community in computer science that focuses on critical systems. And this is our fight. Our fight is to go into software that deals with a lot of important things, and then we go there and we realize that things are not built the way they should be built. And then we try to put a little order in them. But it's also, and I can't stress how helpful partnering with Marie has been, because if you want to go and help those people, you have to understand how they work and you have to establish trust because you're from the outside. And this takes a lot of knowledge of how it works, and Marie's experience has been invaluable in that. And I speak for you, but
No, it's okay.
maybe if you want to elaborate on that. Okay.
Hello, my name is Paulus Meesen. I'm a PhD student at Radboud University Nijmegen. And I think I want to ask you the same question I asked you a year ago. For I agree with the whole software engineering process, but then you were heavily into Catalan in your process and really bringing forward pair programming. And then I asked, is 2 the magical number? 1 lawyer, 1 programmer sitting together. And in the latest iteration of your research, we see that it is, and I think the Normware pointed this out and the idea of business analysts pointed this out, it is so much more disciplinary than just these 2 disciplines. I think you answered then 2 is ideal, more is better, or something. No, I don't know. But
it's like the more the better, but then if it's 30 people in the room, they have to agree, which is difficult.
But that also seems unworkable. So has your stance on that matter changed with this new iteration of your research?
I mean, we were 2, but then we discussed a lot with the people at the ministry, so we were 3, more like 4. But I mean, it depends. As I said to you, there's no magic number. I mean, but it has to be more than 2, and less than 100, because at the end you have to decide that.
Just a quick follow-up. In real life, there is very few people writing or translating law into code, so maybe it's a kind of a simulation of the real condition also.
Yeah, definitely. You would think that there are like hundreds of actors gathering in a big circle, determining all the micro choices. But no, it's just 2 dudes in an office, and they've been tasked by the government because next year there will be 1 person because the government has to shrink, and they do all the things.
But if you consider the issue with a historical perspective, there were many people involved in the process of the sedimentation of the calculation and the writing of the law. So maybe a better perspective is to see how the law has been sedimented by writing process.
2 dudes in a dock, I hope. Pauline?
Hi, Pauline McBride, postdoc here at Cubicle. I was really struck by what you had to say about the number of micro choices, and I think many people reading the paper will have thought, gosh, it does seem as if it's impossible to implement legislation without making those small choices. We very often think about transparency as being transparency about the code, and you touch on that. But isn't what we really need transparency about those micro choices? And I don't mean transparency within the department or the developers, and even that might be a problem. But I really mean being open with citizens that those choices have been made.
So indeed, and this is the discipline we've tried to follow in our code. Whenever we were realizing that we were making a micro choice, because sometimes you make micro choices and you're not even conscious of that, we would put a comment in the code saying, okay, the text says that, we could have interpreted it that way, but it shows that way for these and these reasons. And this is also something that the court would do. Whenever they would be presented with a real case, afterwards the law has been implementing, they would take a decision on the micro choice and then document why they had taken this decision. And we tried to do that, but in advance. we haven't been presented with the real case, but we imagine that the real case could happen in the future, and we try to predetermine what would happen and try to motivate the decision. Of course, we don't have power to decide, actually, because later if somebody doesn't agree with what we decided, they could go to the courts, and then the judge can either validate what we've done, or they say, no, you have to do it the other way. But at least to try to provide some context and motivation on why we did those things.
And just another quick follow-up. The administration does the same with memos, writing notes and things like that. But a few years and decades ago, coder didn't the same. So maybe it's a kind of, I don't know, but administrative framing or comment and explicitation on what's happened when we interpret things.
Thank you. Okay, I think it is 1 o'clock precisely, and that means it is lunchtime.
12 o'clock.
12.
Oh my God, yes. Excuse me. I'm sort of, yes, trying to coordinate myself and many other things. As you must have seen in the chat, Virginia, who was in a tropical storm, maybe she still is, but she is now again available. So we are switching the presentation of the typology from 1, that's why 1 o'clock stuck in my head, of course, from 1 today to tomorrow morning, 9 o'clock. And she will give the keynote between 1 and 1:45 to 2. Wish you great lunch and see you for Virginia at 1 o'clock.